there. My name is Kathleen Arthur, and I am reporting from Olympia, Washington. And you'll see behind me there are a cluster of buildings that are several different government office buildings in the state of Washington, one being the DSHS Children's Services Building. And yesterday I had an appointment with a whole bunch of folk there to try to, kind of talk and problem solve about a very significant issue that has been going on for a long, long time and hasn't gotten any resolve or any attention. So here it is. And this is the email that the head of the department of the secretary is aware of the problem and did schedule a meeting. So when I got there, I did find out then and there that the meeting had been canceled. And so I did ask the security guard when, because I hadn't gotten any notification, and he said it was like that day. So I'm not sure what happened, but it is possible that this email somehow got to them that I sent out. It was an open meeting, right? Open meeting laws, etc. So just before the meeting, I went ahead and asked Frank Chalk and Michelle, who's both incredible child advocates, to please come to this meeting. And then I wrote to them what I was afraid was going on. Because at first, what my sincere fear were for the foster mothers and their inability to report social worker misconduct. But now it's gone much farther beyond that since yesterday in my concerns. So anyway, I'll first tell you about the letter that I wrote. This is to Frank Chop and Michelle. I'm sorry, I can't pronounce her last name, but Caldwell. She's a superstar. Both of them are. Subject: Children Administration, April 10th meeting, federal case, published ruling 15-55563. Our state social workers at DSH have been wearing an invisible coat of immunity. Olympia, we have a problem. Our state DSHS workers have been walking around with an invisible coat of immunity from consequences of lying and planting evidence to remove a child from a parent. A brand new federal ruling has clarified this issue, and it does not bode well for the state district attorney or DSHS employees. Can you attend the meeting tomorrow? Like representative by our state representatives, because there's a big deal going on about, whether your practice, was that you've been doing, that you've been told is correct to do is no longer or was never. So anyway, our 9th District Federal Court judges have just ruled that there is no little lie. Deliberately lying is lying. It's not hearsay. The new ruling sets precedent for our state social worker actions. Clarification about lying and forging documents in order to have parents' child taken has now been clarified. Immunity for lying under the guise of hearsay was sadly a mirage. It was a bad guess by our state's district attorney at a state level. It's a national mirage. It's a national mirage at the state level that went unchecked for 16 long years, a presumed immunity that left the DSHS workers naked. Our social workers were told one thing, and now the federal courts have ruled another thing. How could that happen for so long? This is how. It's sort of like the emperor and his new clothes. He was always naked, but nobody had the courage and the determination to tell him that he was always naked. The cloak of immunity has at long last been judiciously examined on a federal level and found that the immunity for lying was in reality just a mirage. The federal ruling 15-55563, the right to lie case, has clarified that our state district attorneys should have prosecuted DSH workers who they knew were lying and planting evidence, not using taxpayer dollars to represent them. It is a crime to lie and plant evidence in order to take a child from its parents, and the new federal ruling calls it a malicious crime. Even a child knows that a lie is a lie, but our state district attorney have built a web of invisible protection over the DSH workers that never existed. Here's a quote from Thomas Jefferson. Error of opinion may be tolerated if reason is left to combat it. When the DSHS workers acquired a false coat of immunity, parents and children paid the price. The states blocked, all states blocked federal cases prior to case number 15-55563. Our judicial process was blocked, and therefore we, the people, the parents, and the children were not free to combat it. Opinion of immunity was not challenged at a federal level and was assumed to be true by sheer volume, but never allowed to get to the federal level for ruling. So, with this new federal ruling, the clothing of immunity was found to never have been there. The error of opinion from the state district attorneys would have easily dispelled it if the legal process was not blocked and allowed to function as intended. This case, 15-55563, moved to the federal level by a lucky fluke, and it was the first and only of its kind. States blocking case federal level judicial reasonableness checks has had an awful consequence. The entire nation at the state level has spun a web of imaginary protection called immunity and has allowed lies to be introduced as hearsay because everyone did it. All DAs at the state level presumed worker innocence and defend them even if apparent crimes had been committed because a false shield of protection called immunity. But the states did not allow for a reasonableness check by the federal level judicial process. I think they knew they were naked and they didn't want anybody to really point that out. So, with no test case for reasonable objection, the mirage continued as real. The states blocked, all states, not just Washington, all of our states in the nation at the state level have blocked federal clarification of the DSHS workers' right to lie. Case 15-55563 squeaked into the federal court on a date technicality. Praise God. And now, though, we do need to face the inevitable consequences of this ruling. So, remember, this is a very serious deal, and anyway, this is what I was going to talk about, and the meeting was canceled. But luckily, there was a high-level official there available to meet with me. And I talked with her about the right to lie case of the federal government. I assumed that their lawyers had told them and were, instructing them that, hey, the past practice is no longer so. We've been telling you that you have the right to lie. Even if you go into a police office and try to get them arrested, they'll say, no, the social workers have immunity. That was the urban rumor that never got checked because they wouldn't let it get to the federal level. So I was pissed off at the social workers. I'm going to say that right now. I was really pissed off at them because I assumed they knew. But when I met with this high-level official yesterday, it became very apparent that the high-level folks are not letting, the middle level folks know